This is KTN.
Of the governor by way of impeachment was invalid and incompetent as it failed to meet the mandatory threshold under Article 181 of the Constitution and Section 33 of the County Governments Act. And B, that the concept of proxy voting was alien, illegal, and null and void, and the attempt to explain the discrepancy through proxy voting was legally untenable and compounds the illegality of the proceedings premised on acts of fraud, forgery, and misrepresentation. Now, honorable senators, in urging the Senate to find that the threshold of 2/3 of all members of the County Assembly in support of the impeachment motion was not achieved, Counsel Elias Mutuma for the governor stated that the County Assembly of Nyamira comprises 35 members and that therefore the requisite 2/3 majority for a valid impeachment resolution was 24 members of the County Assembly. Council further submitted that the official record of the sitting of the County Assembly held on 25th of November 2025 confirmed that only 19 members were physically present in the Assembly chamber. Council stated that despite this, the Assembly recorded 23 votes in favor of the motion and that this was numerically impossible, and that to him, this demonstrated that improper and fraudulent voting had occurred. Now, Counsel for the Governor submitted that the phrase, all the members of the County Assembly in Section 33(2) of the County Governments Act is not ambiguous and refers to the total composition of the County Assembly as established under Article 177 of the Constitution and as gazetted by the Independent Electoral and Boundaries Commission after the 2022 general elections. Now, Council contended that as a membership of the Nyamira County Assembly is 35 members and as 2/3 of 35 is 23.33, this can only be rounded off to 24 members. Now, Council further submitted that the County Assembly's argument that the 3 vacancies in the Assembly reduce all the members, end quote, from 35 to 32 was legally flawed and absurd. Council therefore urged that for these reasons, the impeachment proceedings before the Senate could not proceed and required to be terminated at the preliminary stage. Now, Council for the County Assembly took a different view on this matter. The thrust of the argument in response to the first preliminary issue was that the Independent Electoral and Boundaries Commission, IEBC, in Gazette number 9956 of 2022, published on 24th August 2022, set out the names of the elected members of the Nyamira County Assembly, and further that this was not the limit or absolute number of members who were required to sit in the Assembly at any given time. Council further noted that when the Constitution and the County Governments Act imposed the requirement of 2/3, this could only refer to 2/3 of the members present at any particular time. According to the Council, an alternative interpretation would mean that no activity could go on should there be a vacancy or a challenge in filling the vacancy, and further, that any business that has been transacted by the County Assembly of Nyamira on the basis of the members of the County Assembly of Nyamira at the time will be null and void. Council further stated that this issue is a question of fact that ought to be determined through the examination of evidence during hearing. On the second limb, on the second limb of the preliminary objection relating to voting by proxy by the 4 members of the County Assembly, Counsel for the Governor stated that this was alien to the County Assembly procedures, illegal and null and void. Council further stated that no authority was granted by any member to vote on their behalf by proxy, and that the 4 members of the County Assembly in whose names proxy votes were recorded had provided sworn statements confirming that they were neither present in the Assembly nor did they issue an authority written or otherwise for any members to vote on their behalf. In this regard, Counsel for the Governor referred to the Standing Order 67 of the Nyamira County Assembly Standing Orders, which requires the decision of the Assembly be made by members present and voting. Counsel argued that the act of proxy voting was expressly prohibited and was a nullity as it contravened Standing Order 67 of the Nyamira County Standing Orders and the principles of representative democracy. It was Council's case that the unauthorized casting of votes in the names of absent members without the authority constituted fraudulent misrepresentation, forgery, and impersonation, further vitiating the entire process. As such, the governor takes the view that the maximum number of voting MCAs would have been 19 MCAs. The governor concludes that the required statutory threshold of 24 members of the County Assembly to support the motion was not achieved. In response, Counsel for the County Assembly stated that the delegation of voting by proxy was carried out in a right manner, and further that the proxy letters were available as evidence of the said delegation. Now, in support of this submission, Counsel referred to the case of Mombasa Biscuit Manufacturing Company Limited versus West End Distributors 1969 EA page 696, which set out the threshold for a preliminary objection. In particular, Counsel stated that the issues raised and in question, that is the number of persons who voted, was a contested fact that ought not to be argued at the preliminary stage. He further stated that although the Governor's Council had indicated that there was evidence of affidavits sworn by 4 members of the County Assembly, averring that they did not delegate such authority, the County Assembly would, at the hearing, provide evidence of mobile telephone and email communication to counter this allegation. It was therefore not possible for the Senate to make a determination on the matter at the preliminary stage without hearing evidence on the matter. Now, Counsel further argued that although proxy voting was not expressly provided for in the standing orders, the Speaker of the Nyamira County Assembly had exercised the discretion provided for Standing Order 1 of the Nyamira County Assembly standing orders to allow for the proxy voting. He further stated that although the standing orders were silent in expressly providing for proxy voting, this did not bar the use of proxy voting in the Assembly. Now, Honorable Senators, following the oral submissions on the preliminary objection and the responses, Senator Edwin Sifuna, Senator Enoch Wambua, and Senator Boni Halwale sought various clarifications from Council, including on the relationship between provisions on the Constitution, on vacation of office by members of Parliament or county assemblies, vis-a-vis the provisions of law as that set out threshold for voting on a matter, at what point the membership of a county assembly is determined after election, or whether this is a moving target, and whether it will not be prudent to give the county assembly the opportunity to adduce evidence on the matters raised in the preliminary objection in the main hearing. Subsequently, the respective council gave the responses to the questions and clarifications sought by honorable senators. Arising from the preliminary issues canvassed, the following are the issues that require determination by the Senate. 1, whether the preliminary objection raised qualifies as a preliminary objection, properly so called, and whether therefore its determination must precede the further progress of the current impeachment process. And 2, if the answer to the first issue is in the affirmative, then whether the 2/3 threshold required for voting on the impeachment motion of the County Assembly was met. Now, honorable senators, I shall commence with the first question, which is whether the preliminary objection raised qualifies as a preliminary objection properly so called, and whether therefore its determination must precede the further progress of the current impeachment process. As you will recall, the Senate has previously been confronted with this question in previous impeachment proceedings. The question of what constitutes a preliminary objection was well set out in the leading case of Mombasa Biscuit Manufacturing Company Limited versus West End Distributors. And this is what, in that matter, the court held. A preliminary objection consists of a point of law which has been pleaded or which arises by clear implication out of the pleadings, and which, if argued as a preliminary point, may dispose of the suit. Examples are on the objection to the jurisdiction of the court or a plea of the limitation or submission that the parties are bound by contract giving rise to the suit to refer the dispute to arbitration. Our preliminary objection raises a pure point of law, which is argued on the assumption that all facts pleaded by the other side are correct. It cannot be raised if any fact has to be ascertained or if what is sought is the exercise of judicial discretion. Now, honorable senators, in light of this similar decision, it is now well settled and established in our practice that a preliminary objection does not require evidence to be adduced as proof of its existence. It is limited to points of law and cannot be raised if a fact has to be ascertained by the use of evidence to be adduced. Reference has been variously made by counsel for the governor and counsel for the county assembly to the jurisprudence that has been laid down by this House in the two Kericho impeachment matters, now commonly referred to as Kericho 1 and Kericho 2, in which the Senate arrived at different conclusions on the nature of preliminary objection and the appropriate place at which to make a determination. In fact, there was no contradiction in the determinations made by this House in Kericho 1 and Kericho 2. In Kericho 1, the Senate determined that a classical preliminary objection was one which is purely on a matter of law and which required no evidence to be adduced for its determination. In that case, it was not in contention that the number of county assembly members who had voted in support of the impeachment motion was 31. It was also not in contention that the total number of Kericho County Assembly members was 47. The only question was whether 31 members constituted the two-thirds threshold as required by law. In Kericho 2, on the other hand, the question was whether some of the county assembly members alleged to have voted in support of the motion did actually vote. This was a matter requiring evidence to be adduced, including the examination and cross-examination of the said county assembly members, and accordingly, this was not a matter that could be determined at a preliminary level without hearing the evidence. Kericho 2 was therefore ruled to belong to the second category of preliminary objection that can only be reasonably subsumed in the full hearing, but for which a determination by the Senate would have to be made at the end before the proceedings to vote on the charges. The question, therefore, is whether the current preliminary objection belongs to the jurisprudence of Kericho 1 or Kericho 2. Now, honorable senators, in the current impeachment proceedings, it is not in contention that there were 19 members in the County Assembly of Nyamira present and voting at the time of impeachment. Secondly, although there is contestation about the validity of the votes purportedly cast by proxy by another 4 members, there is no contestation that the total number of members who voted did not exceed 23 members. The County Assembly, by its own admission, has submitted a list of 23 members as having supported the impeachment. The governor's side, on the other hand, object to this impeachment on the basis that the correct threshold should have been 24 members rather than any lesser number. What is in contention, therefore, is whether the threshold of members required to have voted in the matter is 24 or 23 or lesser number. What is additionally in contention is whether in reckoning the two-thirds threshold, the number of members of the County Assembly is to be applied as 35 or 32. The legal question in contention is whether the number of legislators of the County Assembly remains fixed and unaffected by any vacancies for the purposes of reckoning thresholds, or whether, as Councillor Katwa Keegan for the County Assembly argues, it is a moving target. That cannot be reckoned in advance and depends on the membership of the Assembly at a particular time having subtracted any vacancies existing. Now, honorable senators will appreciate that this is a constitutional and legal questions of the most fundamental ramifications. The decision on which reverberate far and wide and well beyond Nyamira County Assembly, and possibly including this chamber, where at various times and for various reasons we have had vacancies. The decision the Senate takes on this legal question will no doubt bind us going forward in the manner in which we reckon delegations for purposes of voting when there are vacancies in the Senate. From this perspective, it is clear to me that even though a number of matters of fact were raised by the County Assembly in their preliminary objections and fundamental legal questions of threshold, and whether the correct number of delegations that were required to impeach the governor of Nyamira County at the time of the impeachment was undertaken was 24 or 23 or any lesser number is a pure question of law whose determination by the Senate is necessary before these proceedings can continue. This is a preliminary objection of Kericho 1 typology. Honorable Senators, this legal question goes to the substratum of the impeachment proceedings and has the prospect of terminating the proceedings at this point. Accordingly, and as I've guided from this chair before, this kind of preliminary objection raised by the governor requires to be determined by a vote of the Senate, which is the trial court in the impeachment matters. It also obviates the need to answer the second question on whether the threshold was met. Whether the threshold was met, as this is what will be the subject of the vote. Now, the manner of proceedings to this vote will be a motion, moved in the usual manner after notice of motion has been given. Debate will ensue in the usual manner, and the vote will be taken upon the conclusion of debate. To this end, Honorable Senators, I have directed the clerk of the Senate to prepare and circulate a supplementary order paper containing a notice of motion and the motion limited to the preliminary objection on the threshold that was required for this impeachment. Now, Honorable Senators, the decision on the proposed removal from office by impeachment of the county governor and any consequential or incidental decision thereto are matters concerning counties, as has been previously ruled in all impeachment processes undertaken by the Senate. These decisions are made by the Senate by vote, by county delegations. Accordingly, the preliminary issue will be upheld only if it's supported by votes of at least 24 delegations. If the preliminary issue is upheld, this impeachment shall terminate forthwith. If, however, the preliminary objection issue is negated, the Senate will proceed to the main hearing of the impeachment proceedings. It is so ordered. Thank you, Honorable Senators. So, Honorable Senators, you'll be provided with a supplementary order paper that is going to guide us in the proceedings for the afternoon. Order, honorable senators. Please let us take our seats. Honorable senators, let us settle down. Senator Osotsi. The minority leader, kindly take your seat. You know, honorable senators, I want to believe that all of you now have the supplementary order paper. That is the one that is going to guide us. Can Senator Omtata be supplied with the supplementary order paper, please? Senator Onyonka, Senator Fatuma Dulo, Senator Enoch, Senator Hamida, Senator Olekina. It's also in your iPads. In the event that you don't have the physical copy, you can get a soft copy in your iPads before you. Clerk, you may proceed to call the next order.
Order number 2, notice of motion.
The Senate Majority Leader.
Thank you, Mr. Speaker. Mr. Speaker, I rise to give notice of the following motion, which is a preliminary objection by the Governor of Nyamira County on the threshold applied for the proposed removal from office by impeachment of the Governor of Nyamira County. Oh, sorry. Allow me to take it again, Mr. Speaker. This is notice of motion for preliminary objection by the Governor of Nyamira County on the threshold applied for the proposed removal from office by impeachment of the Governor of Nyamira County by the County Assembly. Aware that pursuant to Article 181 of the Constitution and Section 33 of the County Governments Act 2012, on Tuesday the 25th of November 2025, the County Assembly of Nyamira approved a motion for the removal from office by impeachment of Honorable Amos Nyaribo, the Governor of Nyamira County, noting that by letter reference SPK/CAN/1/2025 dated 25th November 2025 and received in the office of the Speaker of the Senate on the 26th of November 2025, the Senate of the approval of the motion by the County Assembly and further forwarded to the Speaker of the Senate documents in evidence of the proceedings of the Assembly, including the list of the 23 members of the County Assembly that voted in favor of the removal from office by impeachment of Governor of Nyamira County. Further noting that one of the preliminary objections raised by Honorable Amos Nyaribo, the Governor of Nyaribo County, was a requisite what did I say? Sorry, Nyamira County. Nyamira County was a requisite threshold for passage of a motion for the removal of governor from office by impeachment, being 2/3 of the members of the County Assembly, as provided for in Section 33 of the County Governments Act and Standing Order 62 of the Standing Orders of the County Assembly of Nyamira, is 24 members of the County Assembly and was not met. Now, therefore, the Senate resolves to uphold the preliminary objection that the threshold required for the removal of a governor from office by impeachment contemplated in Section 33 of the County Governments Act and Standing Order number 62 of the County Assembly of Nyamira was not met, and forthwith terminates the hearing of the proposed removal from office by impeachment of Honorable Amos Nyaribo, the Governor of Nyamira County.
Next order.
Order number 3, motion, preliminary objection by the Governor of Nyamira County on the threshold applied for the proposed removal from office by impeachment of the Governor of Nyamira County by the County Assembly.
Senate Majority Leader.
Mr. Speaker, I rise to move the following motion. This is a preliminary objection by the Governor of Nyamira County on the threshold applied for the proposed removal from office by impeachment of the Governor of Nyamira County by the County Assembly. That, aware that pursuant to Article 181 of the Constitution and Section 33 of the County Governments Act 2012, on Tuesday, the 25th of November, 2025, the County Assembly of Nyamira approved a motion for the removal from office by impeachment of Honorable Amos Nyaribo, the Governor of Nyamira County, noting that by letter reference SPK/CAN/1/2025, dated 25th November 2025, and received in the office of the Speaker of the Senate on the 26th of November 2025, the Speaker of the County Assembly of Nyamira informed the Speaker of the Senate of the approval of the motion by the County Assembly and further forwarded to the Speaker of the Senate documents in evidence of the proceedings of the Assembly, including the list of 23 members of the County Assembly that voted in favor of the removal from office by impeachment of the Governor of Nyamira County, further noting that one of the preliminary objections raised by Honorable Amos Nyaribo, the Governor of Nyamira County, was the requisite threshold for passage of a motion for the removal of a governor from office by impeachment, being 2/3 of the members of the County Assembly, as provided for in Section 33 of the County Governments Act and Standing Order 62 of the Standing Orders of the County Assembly of Nyamira, is 24 of the members of the County Assembly and was not met. Now, therefore, the Senate resolves to uphold the preliminary objection that the threshold required for removal of a governor from office by impeachment contemplated in Section 33 of the County Governments Act and Standing Order number 62 of the County Assembly of Nyamira was not met, and forthwith terminates the hearing on the proceedings on the proposed removal from office by impeachment of Honorable Amos Nyaribo, the Governor of Nyamira County. Mr. Speaker, let me first take time to explain what this motion means. We must celebrate the Senate for how refined our process have become over time. Previously, Mr. Speaker, when we have been faced before this session, by previously I mean before this current Senate, the 13th Parliament, we previously had similar situations where a county assembly will come before the Senate and they'd argue that we have impeached our governor and therefore proceed and listen to this case. And the previous ruling that had been given by the office of the Speaker, which many of us disagreed with and felt was a great travesty of justice, the greatest that has ever happened on the floor of this House, was a ruling that was made back then that an impeachment process ends at the Assembly, and what the Senate needs to look at is a case and the material of it, then make a determination whether that case, whether a case has been made for the impeachment of that governor or not. However, in this present session of the Senate, we have since evolved and refined our processes better to a point where when there is a preliminary objection, the House makes a decision first, which is a good thing, Mr. Speaker, because I believe that with the coming of age of our county assemblies, together with us here in the Senate, we must continue to make the case that there is no alternative to the law. The law is the law, Mr. Speaker. We may not agree with it, it may not be in our favor today, but it is that which binds us and keeps us as a civil society. Anything in the absence of the law, Mr. Speaker, is anarchy. And in the rule of the jungle, it favors nobody. Those in power today or those that don't find the favor of the powers that be. And therefore, we must continue to make the case that in looking into the proceedings such as this, we must first satisfy ourselves as a House of the Senate that the process and the procedure went in tandem as ascribed and prescribed in law, Mr. Speaker. Section 33 of the County Governments Act you'd believe that a plain reading of that section of the law, Mr. Speaker, is something that everybody can easily interpret. In fact, earlier today, while listening to the proceedings, Mr. Speaker, I walked over to the clerk and asked them that what happened to what we used to have back then called the Legislative Summit. I remember attending it 2016 and the subsequent years, because it used to provide a very good forum for exchange of ideas on procedure and processes between the Senate and the 47 county assemblies, Mr. Speaker. Because looking at this case, looking at the case of the 2 impeachments by Kericho, looking at the Isiolo case, it is clear, Mr. Speaker, that there is need for this House, as a House that protects the interests of county governments, must set in law the procedure and make it black and white clear to our colleagues from the county assembly of what is it that the Senate considers to be a foolproof process of the impeachment of a county governor, which when you undertake and you bring it here, we go straight to the process of listening to what your dispute is. Therefore, Mr. Speaker, this is not to tell the people of Nyamira through their representatives that there are no issues in Nyamira. There might be issues, and indeed, listening, because I happen to come from the region, and I know that there are many things. Remember, Mr. Speaker, in this House, we've entertained and even listened and tried to reconcile 2 factions of the same county assembly that were sitting in separate parts of the county, Mr. Speaker. That tells you that there is a problem in that county. But before we get there, Mr. Speaker, we unfortunately must ask ourselves whether this matter is properly before us as a House. That is a question and the import of this motion. Have we been properly invited? Has the governor come through the main door, or has it been thrown in through the windows, Mr. Speaker, to get before the House of the Senate? And as a House that argues and makes the point every day that we must remind the executive, we must remind our county assemblies that we cannot make law, because that is primarily what we do in this House, and then lead the way in violation of the law, unfortunately, Mr. Speaker. And as such, Mr. Speaker, when a matter such as this appears before us, we must be satisfied that indeed there was proper procedure that has been followed. For the last 3 sessions, and this is the part that we take the blame also, you know for a fact that we have refused, and I'm very intentional about the use of the word refused, as Parliament to pass the law on the impeachment procedure. I have never seen a law as critical as this, Mr. Speaker, that has gone round in circles as has been. I can recall from, I don't know, as way back as which year, Mr. Speaker, that there has always been an attempt, but unfortunately, it never gets to the end. That means we are leaving our colleagues in the county assembly to guess and try to find their way on how to follow this procedure. These are issues, some of the issues that this motion is asking us to determine, for example, today, are matters which, if we had set out properly in an impeachment procedure bill, Mr. Speaker, then we wouldn't be debating this. By now, we'd be listening to the case by the county assembly and listening to the response from the county governor. But here we are, unfortunately, Mr. Speaker, it's our country. We must be mindful of it. We have been charged with the responsibility of ensuring that we lead this nation into a state of prosperity by ensuring that people respect the rule of law. Mathematics, Mr. Speaker, is plain and simple. You know that 12 divided by 2 is 6. And you know that if you want to get a third of that 12, Mr. Speaker, then it is 4. If you want 2/3, it is 8. And you'd imagine that in many of our county assemblies, Mr. Speaker, especially following through with the decision that this House made barely a year ago in the first impeachment proceedings against the governor of Kericho County, Mr. Speaker, county assemblies will be aware of the decision of this House, because this House made the decision that there is no quarter or half of a human being. That if you move on to the next, so long as it is a decimal, even if it is 0.1, then it means you go to the next, because the language of the Constitution is not less than, Mr. Speaker. That tells you it cannot be below. If it is 12 and you have 12.1, already 12, it is less than. Therefore, it cannot qualify. And it is for that reason that we have said that so long as you have a decimal beyond the 0.00, you go to the next number. That having been the case, Mr. Speaker, and if our colleagues from the County Assembly of Nyamira had taken time to read through the provisions and the ruling that this House made in that matter last year, Mr. Speaker, they will have appreciated that the requisite quorum as prescribed in law would have been 24, Mr. Speaker. The second item, which is something that I find quite strange, Mr. Speaker, that it is even in their standing orders, because that's what I heard Counsel for the Assembly say. And I say this a lot with tremendous respect to Advocate Katwa Kigen, because he's a senior counsel, somebody I respect, a friend of mine, Mr. Speaker, that in the County Assembly of Nyamira, their standing orders provide for an alien creature, alien to any legislature world over, has a provision called voting by proxy. I have never heard of such an animal, Mr. Speaker. Even as you know, if you follow the proceedings of this House, Mr. Speaker, before we take any vote, the sergeant at arms, after the division bell is rung, always move round to ensure that the voting booth, all the 67 of them, if it is not occupied by an individual voting, then that machine is inactive by removal of the card. That is to prevent exactly that, because it is not possible to transfer your delegated legislation role, Mr. Speaker. And it is not possible to argue and say that I was away, I was at a funeral, and I call my colleague and say, vote for me in this or another way. Mr. Speaker, I don't know. I have not taken time to read the County Assembly's standing orders of Nyamira. And if there is any other county assembly in the Republic of Kenya that has any such provisions, please delete it, because it is an illegality and there is no way that anybody can ever take you serious as a county assembly if you have such provisions in law. The parliamentary practice is as such that you vote as an individual, or if you have delegated power in the case of Senate, for example, if you're a member of a delegation and your head of delegation has given you the mandate to vote, then you can vote on their behalf as it happens. Because Senate is unique, we vote by delegations. But county assemblies vote by individual. They don't vote by delegations. And therefore, that is a second basis upon which we are being asked as a House to consider that particular matter. Therefore, Mr. Speaker, if this House agrees with this motion as moved, it basically means we have not told the County Assembly of Nyamira that you don't have a case before us. We have only told you that the case is not properly before this House. Should you go back, organize yourself, get the requisite numbers and bring it, then we shall open the file and listen to your issues. And you will not be the first that this has happened to. I'll give you the unfortunate example of my own county, that when they came here the first time, they had a similar issue on threshold. And this House sent them back. They went and did what they needed to do, Mr. Speaker. It's not to say that I'm encouraging the County Assembly of Nyamira to go back and do that which they did. That's a decision of their own, Mr. Speaker. But matters must be properly before us. As we speak today, Mr. Speaker, it still pains me when I see two governors, one of them actually Governor Mike Sonko and Governor, what was his name? Governor of Waititu. The truth of the matter, any human being knows that threshold was never achieved in those two county assemblies. In fact, if you read through the pleadings that were brought before us, it was clear and obvious. Yet this House, back then, because of the prevailing political environment in the country at that particular time, we were told in black and white that you are not the county assembly. Don't count. Just proceed and listen to the case. I am happy that at least we have refined our processes to a point that county assemblies know that we will come and check. We will have to satisfy ourselves that you followed the procedure, Mr. Speaker, before eventually making a determination. I made a request earlier on, Mr. Speaker, and perhaps this is my last point because I don't need to belabor. This is a very straight point matter. I want to make my submissions and request the counterpart leader from the minority side to second, then we can listen to our colleagues and make a determination so that if our colleagues are satisfied that those 2 points don't matter, we can proceed and listen to the case. Otherwise, if they choose to be firm and say this is the true state of the matter, Mr. Speaker, because unfortunately, colleagues, the maxim of law making is as such that you must always remember the law that you pass in the hands of your worst enemy. Colleagues senators, tomorrow you can be a cabinet minister, you can be a president, a deputy president, Mr. Speaker, a governor. Will it satisfy you if you know that the procedures of our country are such that even if 5 people met and they say, we have impeached you, then the processing house will listen and say it doesn't matter? Numbers do matter, Mr. Speaker. I don't believe that it was out of lack of something useful to include in our constitutional dispensation, Mr. Speaker, that we set a threshold and a limit that must be attained before a governor comes to this house. And therefore, I convene, having said that, Mr. Speaker, the last point that I wanted to say is that I hope after this process, number one, I want to make the case that we must return the legislative summit. 1, 2, 3 county assemblies tells you that there is a problem in our county assemblies, that there is something that we don't seem to be reading from the same script. And impeachment is not just a political tool to be used on your enemy. It is a procedure of law which unfortunately you must either attain, and if you fail to attain it, Mr. Speaker, there are consequences to it. Why should we go back to the legislative summit? It is so that this house, led by a very competent technical staff, Mr. Speaker, can set out, including, Mr. Speaker, the charges that needs to be brought before us. I don't want to say a lot because I have to balance also between the things that I say, Mr. Speaker, and appearing as if I disagree completely with what the county assembly is saying. But I believe even in laying out the charges before a county governor, we must then provide the template as parliament. I think today's charges, Mr. Speaker, and I've listened to close to 20 impeachments in this house, was the longest. The charges were read for almost 30 minutes. Even the person being accused, Mr. Speaker, by the time they are rising to plead, either guilty or not, they have forgotten what the initial charges were, Mr. Speaker. We must at least do better and develop the template for that particular item, Mr. Speaker. Therefore, I don't want to say more than that. I think I have said everything that I need to say. Colleagues, the decision is yours. I want to sit and listen also. That's my perception and what I feel about this particular matter. But ultimately, the decision is yours. Remember, you're seated as a jury. And ultimately, you have to satisfy yourself before making a decision whether to proceed and now open the case or terminate it because it is not properly before us. With those many remarks, Mr. Speaker, I beg to move and request the Leader of Minority, Justice Retired Stewart Matsayo, to second this motion. I thank you, Mr. Speaker.
Asante mstahiki Spika. Mstahiki Spika, kwanza nataka kuunga mkono aliyosema yote ndugu yangu Aaron Cheriot. Kitu cha kwanza lazima tuelewe ya kwamba huu ni mtihani mkubwa sana ambao sisi kama senators katika hili bunge lazima tuzingatie. Kitu cha kwanza ni kwamba kumwachisha kazi ama kuangalia zile taratibu za kumwachisha kazi gavana wa Kisii sio jambo jipya kwetu. Lakini kitu ni kwamba cha kusikitisha ni kwamba katika hizi counties zote ambazo sisi tunaweza kwamba tuko hapa na tunazisaidia, ni kwamba masikizano yanakuwa kidogo sana. Mimi ningeomba kitu kimoja. Ukiwa gavana, kuwa na taratibu za kusikiza wenzako, kuwa na taratibu za kuelewana na wenzako ili uweze kuendesha uongozi wako bila matatizo yote. Hivi sasa tunaona ya kwamba kuna mstakabali mmoja umeletwa hapo katikati ya kwamba kesi hii iweze kumalizwa. Ni kweli tumefanya kesi kama hizi hapo awali, lakini kesi hii ni kesi ya kunukuu, ni kesi ya kuangalia kwamba je, ile nambari ambayo imepewa inaweza kushuka chini? Je, nambari ile ambayo imepewa kama ni ya 24 inaweza kupanda juu? Kitu ni kwamba ni umuhimu sana sisi kama maseneta, ndugu zangu, nataka tuangalie, je, hii goli ikiwa iko pale unaweza kuitoa ukaweka mahali pengine? Jibu ni kwamba la.